Welcome to our webinar. We have some special guests here today. We're going to be talking about everything you need to know about buying or selling a cannabis license and equity in the state of Minnesota. I'm your host, Lucas McCann. I come from CannDelta. We're a regulatory and scientific cannabis consulting company. And I've got Carol Moss from Helmuth
Helmuth
Hel
and Johnson.
and Johnson. Thank you, Carol. And Ilana.
Ilana McIntosh from Helmuth and Johnson. Hello.
Appreciate you both joining. We're very excited to be picking your brain today and learning everything that we need to know about the process of buying or selling a license as it is. Before we get started with your introductions, I'll introduce myself quickly. I'm Dr. Lucas McCann. I'm the CSO and co-founder of CannDelta. We're a regulatory and scientific cannabis consulting company. My background's actually not in law, it's in medicinal organic chemistry, but I've been working with licensing, product commercialization, and helping to launch licenses across the country since 2018. I'm very pleased to be leading this webinar. We've been getting a ton of inquiries about what it looks like to get involved in the Minnesota cannabis industry should folks have missed the lotteries that have taken place over the last year. So very exciting. So to start, we'd like to learn a little bit more about you folks. So Carol Moss, love to learn about what it is that's brought you here today.
Thank you, Lucas, and thank you, CannDelta, for having us. We're super excited. We've been also getting a lot of questions and calls regarding the transfer of equity and license. So I appreciate the timing of this. So my name is Carol Moss. I am the head of the cannabis industry practice group here at Helmuth and Johnson. I have been in the Minnesota cannabis and hemp field before even the low dose came to Minnesota. So we're in dog years. That's a long time to be in the industry. I was selected to serve on the Cannabis Advisory Council for the Office of Cannabis Management. I was on advisory board for the coalition to help write and pass the legalization bill in 2023. So as Lucas said, we're Helmuth and Johnson. We are a full service business law firm. Our main law firm office is in Edina, where Ilana and I are located, but we have 3 offices across the state and about 70 attorneys. So we are your one-stop shop for business needs. And I always say that cannabis businesses are just businesses with pizzazz. So we bring in a lot of our colleagues to help our cannabis and hemp clients. So thank you very much for having us.
Thank you, Carol. It's a pleasure. And Ilana, please, over to you.
Hi, Ilana McIntosh. Thank you guys for having us join you today on this webinar. I like that, Carol. Cannabis businesses are businesses with pizzazz. My name is Ilana, and I am a corporate and real estate attorney at Helmuth and Johnson. I specialize in commercial real estate, mergers and acquisitions, and corporate work, which means that I am doing a lot of the work related to the cannabis transactions that we have currently, as most of the clients that we service in the cannabis industry at this moment are not in litigation. They're in the transactional stage of their businesses and operations. I've been supporting Carol's clients in the real estate, corporate, and mergers and acquisition stage at this time.
Thank you, Ilana. And where are you folks located? Where are the firm offices?
We are located in Edina, so west of the west quadrant of the city. If you're from Minnesota, behind me is 494 and 169.
We'll get started. So CannDelta is putting this together. We are a team of business strategists, regulatory experts, and scientists, and folks who are dying to know. So we've got an hour where we're off the clock with 2 of the top cannabis lawyers, I would say, in the state of Minnesota, to be able to pick their brains and really tease apart their gray matter to understand how M&A is really working in the cannabis industry. So for those who are interested, CannDelta is based in New York. We have a New York office at 99 Hudson Street at Hudson and Franklin. We're in the Tribeca area, and we are also across the country. So happy to meet with anyone over Zoom who might have questions about launching their business. We've launched over 400 in the last 8 years that we've been around, and sometimes people ask for our opinion. So we put that opinion in some articles, Forbes, Marijuana Moment, Benzinga, and others which are listed here. Our clients span the verticals from the production side, cultivation, manufacturing, and processing, to analytical testing and even retail dispensary. We've helped establish folks in every part of the verticals of the cannabis industry. And for those who are interested, we do have an excellent free resource online, which would summarize everything up into Minnesota cannabis to today's date. It's our Minnesota post-licensing ebook, which makes some excellent recommendations about what to do and certainly what not to do with your preliminary license in hand. As we go forward with this webinar, our goal is really to help support anyone who is perhaps looking to buy, sell, or launch a cannabis business in the state of Minnesota. Now, we've recently had a lottery and licenses have been awarded across the states. That lottery is now closed. So getting a license in the state is not possible if you miss the boat on that opportunity window. However, even though you can't apply directly, there could be opportunities for those looking to buy their way into purchasing equity in entities that own the business. And that's going to be the crux of our webinar today. So we're really excited about that. We have helped over 50 applicants submit their application successfully. Minnesota's probably got one of the toughest applications we've seen in the state. It is very, very detailed with the amount of information that has to go in there. So it wasn't something that people really could do very well if they kind of did it last minute. It required a lot of planning, a lot of promises being made, and a lot of detail that's being evaluated from the state now. So for those who have been awarded their preliminary license, they need to be converted into full licenses in the next 18 months. We're well into that 18-month timeline now. So that is a pretty aggressive timeline. We notice that many people, when they're setting up these businesses elsewhere, can sometimes take 2 to 3 years. So this is aggressive. The OCM wants to see the cannabis industry really take off. Now, will that timeline maybe be massaged? We'll have to see, but really there is an opportunity here for the state to sort of set some limits as to how long people can hold on to these licenses for if they don't intend to do anything with them. This is really what I think that signals more than anything else. So what we have now, mostly, I would say probably 99% of the license holders are at the preliminary stages. They have a preliminary license. And now that means that the third-party background checks have been passed. They've submitted the LPAs, and this license is the interim license that doesn't allow for any cannabis activity to really occur, right? For that, you'd have to get the full cannabis license. But what it does allow for is for people to take on investors, and potentially there could be some potential for some M&A activity, buying and selling equity. Changing your organizational structure is one of the few things that you can actually do with your preliminary license, right? But you can't buy, you can't sell cannabis, but you can set up the core fundamentals of what your business should look like. And most of that involves looking for your physical location, which becomes a very important component of that application, not just in terms of the operations and the compliance with local and municipal and state zoning laws, but also really is the core key feature for where the cannabis activity can really occur and can certainly add a lot of value to a potential license if you're looking to divest of some or all of the equity in your license. So now we sort of set the stage for where we're at. Let's talk a little bit about the market context and opportunity. So, we've got quite a sizable market here, 7 million people in the state. I guess just sort of off the cuff here, Carol and Ilana, what are your thoughts on the addressable market?
Thank you, Lucas. Just to take a little bit of step back and fill in some pieces, that 18 months, if you are a mezzo license, you have to get 2 of your 3 endorsements up within that 18 months. But there is an opportunity to show good cause and get an extension of 6 months if you approach the OCM. So just kind of filling in. So I mean, Minnesota, we have been really busy. As a lot of people know, we did not have a robust medical market that we just flipped the switch. We had to start from pretty much zero to create our market. And so now that we are at the exciting point where people know what license they are going to have the ability to get, a lot of activity has been going on. Real estate is a big thing. We've been dealing with a lot of zoning. We've been dealing with a lot of local governments. One of the biggest things that I see right now are difficulties with any retail establishments, whether you have a retail license or a micro mezzo with the retail endorsement. Cities are able to limit the number of retail stores that they will allow in their cities. And those caps or those spots are getting filled up very, very quickly. And as that happens, I see the value of retail licenses going down, or I see the difficulties with people with micro and mesos. So there's still a lot of opportunity. We're super excited. We have a lot of great investors and cities, counties that do want these businesses. But yeah, it's been really a challenge in the retail market.
Yeah, Ilana, same question. Anything to add there about some of the trends that you've been seeing about the licenses? Are there some that perhaps folks are a little bit more interested than others? Are they all equally valuable?
Actually, I think that's more of a Carol question because all of these letters of intent and opportunities come to her before they get channeled to me.
Great. And then Carol, what are your thoughts? Are there some licenses that are inherently more valuable than others?
Yeah, so the micro and the meso, actually, I would put the meso as the most valuable one. That's a micro mesos allow complete vertical integration. A meso allows you to be the largest, 15,000 square feet manufacturing and 3 stores. So those will continue to always be the most valuable ones. And as I mentioned, the retail has been very, very difficult, but we see in a lot of markets at 3 to 5 years. Unfortunately, a lot of consolidation. So if you have a meso and you only need to do 2 out of the 3 endorsements, supply is a very difficult thing right now. So if you start with cultivation, manufacturing, you can always get retail later. But as for our market, the biggest thing right now is supply. We have stores that are getting licensed that cannot find anything to put on their shelves. And so I have clients who have received license but are not marketing or not announcing them because they don't have supply and they don't want people to come into their store asking and seeing that they don't have supply, ruining their brand even before it gets off the ground. We're hoping that that supply will come as cultivators are up and running. And also we're not requiring cultivators to start at seeds. They can start at larger plants. The tribes are coming off of tribal land. There's some medical business combo license that could provide some supply. So it's going to be tight in the beginning for a lot of retailers to open up their doors anytime soon.
Now, there was an article that came out, I believe, last week that was published in the state about having the tribes potentially supply the adult use market. Can you confirm or deny some of those rumors
Yeah.
that have been circulating?
Yeah, so there are, I can't remember, it's 8 or 10 tribes that are doing cannabis businesses on their tribal land as they are allowed. They're completely sovereign in the state of Minnesota. Minnesota has been negotiating compacts with these tribes that will allow these tribes to come off of tribal land and own and operate cannabis businesses right off of tribal land. They'll be able to enter into business agreements and contracts with non-tribal parties. So White Earth was the first one that signed it, and now we have the Mille Lacs Band of Ojibwe who signed it last week. So those two tribes are White Earth has been off the tribal lands for a while now, but they're starting to sign those compacts, and that will be a source of supply because they'll be able to take the plants that they've been growing, the flower, and then take it off of tribal land and also do big grows off of tribal land.
Interesting. Now, we have different kinds of licenses that are available, not just in size of the operations or the potential for the certain kinds of endorsements. There are some ones that are titled very, very appropriately, like the cultivator license, manufacturing license, which speaks to what endorsements that are allowed. But in terms of maybe value or perceived value,
Yeah.
what would you say is sort of the range or the spectrum for what some of these licenses may look like in terms of, what they could go for in terms of, I guess, cost?
Yeah, so one of the first things, the factors that we look at when considering a equity purchase or equity sale is whether the applicant was a social equity applicant or not. And that is a significant factor because you cannot sell your equity in a business. If you applied as a social equity applicant, your pool of people that could purchase your entity is much smaller because you have to sell to another social equity applicant. So if you got a license that you obtained without being a social equity applicant, obviously your pool of potential buyers is much higher. So we see that those license or those equities are valued more. Because if you're social equity, that license has to be held by a social equity applicant 65% for 3 years. It doesn't have to be one social equity applicant, and you can sell to another social equity applicant, but that 65% is really big through all of this, because it's not even just ownership. Like OCM has put out guidance that they're looking at that 65% for control and of getting distribution and getting financial benefits through that three years. So OCM has been putting out guidance to make sure there's no just paper social equity applicants. So that's a big thing. And then we're seeing, people having more and more trouble with retail. And so, I've seen those values come down. But people want to be vertically integrated. So that's mostly the micro, which is uncapped, and then the mesos, which are capped.
Okay, so an uncapped micro license. I would think that because there's no limit to that, that their inherent value would be significantly less than something like a meso license.
Correct. They would be because, supply and demand, right? I think there were like 1,800 applicants for micros. And talking to a lot of people who had no intention of really opening cannabis. They thought they could get a micro and then make big bucks or win big. And I got to tell them, like, sorry, like there are lots of people trying to sell just like you, and I dash their hopes or bring them back to earth. So yes, there are micros, it's a significant number out there. And then meso, which allows you the bigger integration, that is capped. So there are only a certain amount of meso license available, making them even more valuable.
For the ecosystem that all these folks exist in, I mean, they're not isolated. Can they still participate by moving product between these businesses?
Yeah, so I mean, the micro and the meso allows you to do a lot of integration, between your different endorsements, your different steps, but different parts of other businesses. So we are really looking at cannabis or micro businesses and meso businesses to really add to the canopy that will give us that initial supply. It's just going to be a lot different when we have micros that are capped at 5,000 square feet indoor, 1 acre outdoor. So you are able to just focus on one. Let's say you're a cultivator, you just get micro, you just do a cultivator. Or I have a husband and wife way up northern Minnesota, mom and pop shop. They just want to do their one store, serve their community, and that's it. And they're able to buy supply from other people to just have their store.
So I mean, this is very different from, what New York has done with their micro business. And I know some things were somewhat borrowed from New York's OCM in terms of the license type. There's no meso in New York, and the micro license doesn't have the sort of same eat what you kill model. So you're not required to sell only your own products. You can bring in the products from others with your one store as a micro.
Yeah, that's exactly it. And I think that, there's nothing a Minnesotan loves more than Minnesota. And so we always think, we're above average. So I like the way that we set up our micros because we wanted to create a craft industry, kind of like craft brewery here in Minnesota, and allowing somebody to just have one store, just do one cultivation really helps us get to that goal.
Now, this might be maybe one for Ilana, but it's either to either of you, with the number of licenses that are available that require, or that have a potential for retail endorsement. So I guess that would include the micros, the mesos, and the retailer. Is there enough actual compliant property in Minnesota to sort of allow each of these license holders to be able to open and operationalize?
There's definitely challenges there. I think Carol touched on some of that earlier. I think that if you're looking at real estate, you'll note that there are a lot of properties that are not available to a cannabis retailer due to the buffer requirements, city ordinances, zoning potential issues, and then the availability of facilities that would, or spaces that are available. Um, and some of that has to do with the mortgages that are an encumbrance on the properties. We can talk about that a little bit further, a little bit more later on. But yeah, I think that the availability of space is definitely a hurdle for the retailers.
Great. And it's one thing to sort of find a property that's compliant, but if you're not in an ideal location, it doesn't really matter if no one's going to see you.
Right.
Um,
They say that the most important thing in real estate is location, 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 right? It's true for businesses as well.
100%. So when we start looking at some of the compliant areas, is clustering of stores a potential problem that we might see in the market?
Um, I would maybe I don't think it's going to be a big deal. Kind of just stepping back, as I mentioned, cities are putting caps. Most cities, I would say about 90% of cities are putting caps in the number of retails that they have based on population. So in those cities, I don't think they'll be clustering because they're usually not allowing more than 2 or 3 in their cities. Um, that's one of the big problems that we're seeing with real estate. And my hope is in 2 to 3 years, cities will realize that these are good businesses to have in their community. They can bring people in shopping for the day, tourism, tax revenue. So I'm very hopeful that cities will get over this initial scare mentality, and then open up their businesses or their cities to allow for more retail spaces. But we are having problems with cities, not because some are, I would just say, are adversarial to cannabis. Some of them just don't understand cannabis. And so that's been a really big struggle. One example is manufacturing. I had one city who thought, Breaking Bad, like they thought that like manufacturing was going to be that bad. And I had to explain, well, manufacturing is making pre-rolls too, making brownies. So that's going to be a big thing is when you deal with local governments, when you find a place, you'll be dealing with that local government quite a bit.
Now, from a landlord's perspective, cannabis tenants, do they make good tenants? I mean, are they sort of like a fly-by-night operation?
We hope not. I mean, the goal is that they're not. Usually, we talk about the green tax quite a bit in cannabis, meaning, um, things typically cost more. I always tell people like, we're not dealing with coffee beans, right? We are dealing in a risky industry, no matter where you are, no matter how much you mitigate the risk. And so cannabis being the risky industry it is, a lot of landlords see this as an opportunity to get premium dollar for their spaces. Also knowing the difficulty in finding space for people. So that's one thing that we are seeing quite a bit. We're seeing twice I've been in situations where a landlord gave an LOI to the client in order to get the registration. Client gets the registration and all of a sudden the landlord wants to sell the building, not lease it. And so you're in this like difficult scenario where you got this valuable registration and now the landlord is changing his or her mind. So there are a lot of challenges in finding locations and dealing with landlords.
Once a cannabis tenant's kind of locked in, I mean, I would think that the behavior is that they're not just going to necessarily want to move across the street if the rent becomes slightly cheaper,
Right.
right? I mean, these
Yeah.
these these licenses are tied to a physical site. So if you set up shop, I mean, I would think the tendency would be to really lock in and sink your teeth in for a 5-year lease.
Yeah, I mean, I've even recommended longer than 5 years. If you find a good location, you got a good lease. Maybe that landlord didn't know about the green tax and is charging you fair rent. You know, I tell clients, lock that baby in, get some options to renew in the contract. Because if you get to a point where you want to sell your cannabis business, having a locked in lease adds a lot of value to your business. So in the case that you do find a landlord, do find a good scenario, get as many options to renew as you can. I've had clients who come, they just get a two-year lease. And I'm like, well, what is the landlord going to do after 2 years? And he sees that you're successful. He's going to double your rent. So you can actually be setting yourself up for a bad situation if you aren't locking in a lease for a longer period of time.
But I think it also depends, guys, on the complexity of the tenant's build out, right? I mean, if you're a manufacturing facility and you have to invest a lot of money into build out and equipment that's not so easily movable, then you're gonna try to look for or lock in a longer term lease. But if it's a retail store that doesn't require much build out and we're just talking about furniture, fixtures, and equipment, then maybe it's not that big of a consideration and you want a shorter term lease and kind of determine how business is in that location before locking in a longer lease term. And maybe one of the things that a tenant can do is negotiate the ability for extension options. So if you're looking at a lease term that's 5 years and you think, well, this is a really great facility, I might want to have it for a longer term, you can always negotiate an extension option at the front end so that you could have the option to convert your 5-year lease to a 10-year lease.
Are we able to, at this time, sort of comment on general dollars per square foot values that we're seeing, maybe outside of the green tax? What is sort of the magnitude of what this tax looks like? Is it 5x, 10x?
Yeah, I don't have enough to give that opinion. But what I am telling clients that if they are in a situation with a friendly landlord, let's say their landlord wants to be an investor, or their landlord is a family member. What we try to do is set it up so that if there's a lot of build out that needs to be done and maintenance on that building, that's put on the landlord to take care of. Like the landlord has the responsibility for plowing snow and everything like that, because those are expenses that a landlord can deduct from his or her taxes, whereas the cannabis business cannot. And then in exchange for the landlord taking all those expenses on, then charge a higher rent for the cannabis business, because some rent, more if you're in manufacturing or cultivation, does go to the cost of goods sold. So if you can maximize that part so that you can deduct it, and then the landlord takes those expenses and is able to deduct them from his taxes, it can be a high rent situation, could be beneficial to the cannabis business.
Interesting. So now we're talking about 280E strategy in addition to potentially an equity strategy here.
Yep.
Okay, very cool. Let's move this forward because I know we've got a lot to cover. Now, in terms of some of the questions that might exist around legal and the regulatory framework, the rules and the laws that we're speaking to. What can we actually do at this point in the market? What can really be done?
Yeah, this is a great question because OCM, our Office of Cannabis Management, put out 5 bullet points guiding the exchange or the change in ownership or equity. And while I sort of disagree with OCM on some of their guidance, we do try to structure our deal to fit within there. Because it's not in our client's best interest to spend time and resources and money fighting with OCM. So let's just get the deal done. So we do try to fit within those 5 bullet points. And they're pretty, our statute specifically states that you cannot transfer a pre-approval. You can transfer the license. So what we do is we look at the entity that has the license for selling. But OCM's guidance includes and the first couple are the big ones. We can't change the ownership interest of the entity that changes majority ownership. So if somebody is owning 75, they at least have to own 51% through this process. They can't make a change that require a new business registration, going from an LLC to a corporation. Make any transfers that would violate social equity. We talked about a little bit about if you're a social equity applicant, you pretty much have to sell to a social equity applicant. That needs to be there. And then OCM will look at, making sure that the new buyer or the new entity or owner coming in isn't disqualified from having a cannabis license, such as, conviction for fraud. And then also the true party of interest. And I really want people to remember that the true party of interest can really come up and really torpedo a deal. A lot of people think that true party of interest involves ownership. It is not just ownership of a business. It's whether you have, the OCM looks to whether you have an interest in how a business does financially. So if I am a landlord and I am getting 5% of somebody's cannabis profits, one of my tenants, I am a true party of interest in my tenant's business, even though I don't own any of that business. And if I have another cannabis business I'm doing that same thing to, I'm putting both of my clients at risk. And it's the same as when you are owning the entity. If you are working with multiple license holders, you could be torpedoing everybody. So that's a really strong analysis that has to be done on the front end. And a lot of people just kind of gloss over that, unfortunately. But really, the main ones that we talk about, the main ones that Ilana and I have been working for, is the transfer of ownership interest that doesn't change majority ownership. That's the big one that has really affected how we structure these deals the most.
So, Carol, you mentioned something that's really interesting there that might sort of draw a parallel with some ways that the New York framework could work, and that's around what branding and marketing could look like. So, New York's one of the only states that has implemented a license for those that wish to operate as a brand. But it sounds like, from what you're saying, if a brand were to come to market and somehow have an interest, a proven financial interest for how some of these businesses are actually doing, that they themselves could be nexused.
Yeah, they could, anytime you are a party that is receiving a percentage of any kind of cannabis business profits, you are becoming a true party of interest for that cannabis business. And that can happen like a numerous number of ways, just like the landlord scenario I put out, master service agreements, you're a consultant. If you get a percentage, you're a true party of interest. If you have a certain kind of agreement on the brand, that could make you a true party of interest. So there are a lot of ways that you become a true party of interest. And what that means is if you are prohibited from owning two licenses at the same time, you cannot have a retail license and a micro license at the same time. It's just prohibited in the statute. If you become true party of interest in these two businesses, you're putting both license at risk. So yeah, this can come up quite a bit, and it's really something that needs to be taken seriously.
So it sounds like if I'm a license holder, I should really be doing my due diligence about who I'm bringing in as an investor, because now you're saying if they're involved in another business and their business is such that they can't hold interest in both theirs and mine, I
Yeah.
could be putting myself in jeopardy as a license holder.
Absolutely. Absolutely. And one of the other things that we do, like when we form our operating agreements or our bylaws or shareholder agreements, we always put in information or provisions in there if that scenario should happen. Because we're always looking at protecting the license at all costs. And so we have provisions in our corporate documents that would literally kick that person out or buy them out at dirt cheap in order to make sure that people do not do that.
But what that means is you also have to conduct due diligence on your your landlord or other people that are partners with you if you're going to be sharing any amount of revenue with them.
Mhm. Yeah.
So as Carol mentioned, we've had a couple of clients actually that have gotten a little bit more creative with their leasing situation where they'll offer the landlord a percentage of their revenue for a space. And oftentimes landlords find that to be pretty appealing. But what that means is that landlord be couldn't accept the same type of arrangement with a different cannabis entrepreneur business in a different facility because now they'd be the true party of interest in two different licensures.
This is interesting. So, we're very aware of companies that are out there buying up real estate for the purposes of renting them back at close to or maybe more expensive than market value, but do have clauses in their agreements that include shelf space and some kind of profit share model. So
Mm.
that's really something that you really have to know then if you're going to be renting from someone who owns property and owns several of them and is doing the same thing with others.
Mhm.
Absolutely.
So getting back to, I guess, sort of the real meat of this conversation, and in terms of how these things are structured, I think what everyone wants to know is based on the OCM's guidance and maybe not the statutes, is 100% equity deal possible for a non-social equity license off the hop?
Well, not at the pre-approval stage. You, as a buyer, could purchase 51% of an entity's interests, ownership interests, and do a two-prong approach where you close on the other 49% after the seller receives their full license approval. But keep in mind too that the transferee also has to be approved by the Office of Cannabis Management. So your deal has to be contingent on the buyer also receiving approval after the license has been fully approved and then transferred.
So we're talking about two, maybe even three benchmarks for close. We've got now sort of the deal docs being signed, the license becoming annual, and then the OCM finally approving the whole thing.
Right.
Correct.
So this is a very delicate kind of situation that folks are getting into with very intricate deal docs, from what I would imagine, based on how you've explained them, where we've got multiple timelines kind of existing, with
Mhm.
one single transaction for one entity that holds a license.
Yep,
Yeah.
it's very, very unique in the way that you have to structure these that are unlike many other businesses that you might buy or sell because they're operations of going concern.
Yeah, I mean, our biggest concern, and I want every time we get a new deal, we spend most of the time thinking about the time period between, the first closing, the buyer has 49%, and when the buyer gets the second 51% to get the whole thing. Like this period of time is the riskiest for the buyer because OCM requires the original applicant to maintain control. So who has
Will
gonna
maintain 51%.
what?
They need to maintain
Yeah,
51%
so they have
ownership
to
interest.
maintain 51%, but they also have to maintain, that means they maintain control of the entity. So who's going to be making the decisions on signing a lease? Who's going to be making the decisions on taking on investors? Who's going to be making the decisions about whether or not to get a credit card or not, or to hire a consultant or hire an attorney? All of those decisions, while it might be the buyer that is trying to do all of that in order to get to the end and get the license, it's really, that is probably the riskiest point of the transaction. Um, because as we mentioned earlier, the license is not given by OCM until you have a store up and running or you have your cultivation or manufacturing up and running. And to get to that point, sometimes takes a lot of money. And who's going to pay that? Not the seller. He's going to be bouncing out soon. So the buyer.
But we do have some pretty good mechanisms when we represent the buyer to help alleviate those risks for the buyer. And some of it kind of relates to not ownership interest percentage, but control of decisions and
This is
management of the
this
operation.
very important conversation because we see a lot of these deals, they transact where the original applicant or preliminary license holder will have 51%, but they'll enter into some kind of LOI or a master services agreement where the other entity might have some kind of decision-making power, to act kind of in their absence as they're really not involved in the business. How
Mhm.
does the OCM have the capacity to sort of evaluate for fairness and evaluate for compliance when looking at these kinds of arrangements?
That's a really good question because the feedback we're getting from OCM is that they will not look at a change of ownership in the equity or anything like that until you get to the final stages where you update your capitalization table or you update your final docs, your SOPs. And you also always have to submit your contracts to OCM. You're always going to be required to do that. So just remember, like, no shenanigans in documents because OCM is going to review them. So we would hate to get to that endpoint. We get everything done, the final docs, the build out, only to have OCM come back and say, oh no, we don't approve this because you really pushed out the seller at the very beginning. Um, Again, like I will say till the day I die, cannabis is so extremely risky. And so Ilana and I just try to do as many things to mitigate those risks as possible. But it is, we can't protect everything. So it is a very risky situation.
This might be a good time, Lucas, to switch to the next slide. I think we talk a little bit
Mm,
about the deal structure. Um, and key terms, LOIs, et cetera. At this stage, a lot of Carol's clients have sent over letter of intent, which absolutely is a step that I would not advise skipping. What a letter of intent or LOI is a non-binding letter that the parties enter into that indicate the material terms of the transaction. Since this is such a complicated and complex deal, the way that it's structured with the potential two-prong approach and an 18-month build out for licensure approval with the contingencies of OCM approval, a letter of intent is absolutely necessary. What that will set forth is your material terms such as the who, what, where, when, how, and why of a transaction. So that is something that we would recommend that you get your lawyer involved in, because although it's non-binding, we handle and structure these transactions all the time. So we can review the letter of intent and let the parties know where the inconsistencies lie. Because oftentimes, we'll receive letter of intents, and one section will say that the buyer is going to purchase the company, and in other sections it says it's just for the license. And obviously, those are two very different considerations. The licensure itself is an asset that's owned by the company, and the company is the ownership interests of the actual entity. And so, if we're walking into the transaction and parties have two completely different ideas of what they're getting, then we don't have a deal or a material term to structure that transaction off of. The purchase agreement for a license transfer versus a ownership interest transfer looks completely different. And we're going to require different reps and warranties from the parties, depending on whether it's one or the other. And then the two-prong approach of the closing, which we had mentioned earlier about ownership interest transfer, because you can only take 49% on the first prong and 51% on the second prong. Well, if you're buying a license rather than ownership interest, we're looking at something totally different. We would not have a closing until the seller has actually obtained a license and become a licensed entity, and then the buyer would buy that license, and all that is the right to engage or operate in a cannabis related business. It does not give you the entity itself and its brand and all of the other things that an entity might own.
Alana, you touched on some very key things there that I think are really important for what cannabis M&A, or at least equity transfer, looks like in the States. So license transfer, very different again than ownership interest. But
Mhm.
hypothetical situation, if I owned a laundromat under, let's say, an LLC, Lucas's Laundromat LLC, with employees, contracts, assets, liabilities, and that same entity, I use that to apply for my license. How does that going to make things more difficult or complex if I'm also trying to now sell some of my ownership interest? Does it?
Eh, So, yes, absolutely. Because if I am buying Lucas's Laundromat LLC, by the way, that's a great name, you should trademark it, then I am going to get everything that Lucas's Laundromat owns and operates, and that would be the laundromat too. And so if you're getting a license under your Lucas's Laundromat LLC, then you have basically two business operations or almost two separate divisions under that company. Um, and when you sell it, you're selling the whole kit and caboodle. You're selling the liabilities that go with it too. So you'll be selling, the lease that the laundromat is sitting in if you're leasing the space. You'll be selling the contracts that you have, whether they're, rights or obligations under those contracts, they all go with the ownership interest of the company. Now, if Lucas's Laundromats buys or has a license and it's only selling the license, the buyer would only obtain the right to sell cannabis that you own under your license.
I just
Flipping the tape.
yeah, I
No,
just like
go
to
ahead,
add,
Carol.
please, Lucas,
Yeah,
please don't do that. Don't mix your
Yeah,
cannabis business with your non-cannabis business. Um,
not a good idea.
no, don't do it. Don't do it. You're gonna get 280E. You're gonna have so many tax issues and regulatories. Don't. So I just had to say that.
and sure, we're talking about the royal you
It's a
here.
good,
Lucas's
it's
laundromat does not
Yeah, Lucas,
exist,
don't
but
do that.
it's a good illustration though to help people understand what that means.
right. And let's say flipping the table here. Now I'm an investor and I'm looking at, the license holding entity, Lucas's Laundromat, and I think this looks like a great opportunity for me to, let's say pick up a micro for $60,000, where I'm going to buy the entity that holds the license. I should be asking questions about what that LLC sort of has in terms of liabilities, because the laundromat could owe 30 million in back taxes.
Well, I would say that that's true whether it operates another business or not. When you're a buyer, you're going to want to look at the seller's, um, you want to look under the hood of everything the seller has done. So, that's every contract the seller has entered into, every liability the contractor has, credit cards, the ownership interest of the entity. Maybe they've already promised somebody 5% ownership. Or, they've encumbered the ownership interest in some way that you're not aware of. So due diligence is a huge component of the transaction, and I would recommend it for both seller and buyer. As a seller, you want to make sure that the buyer has the financial wherewithal to purchase the ownership interest that you're looking to sell. Because as we mentioned, we might have a two-prong approach to the closing, right? So they're going to buy 49% outright, but what about the 51%? Once you've completed the complete build out for the facility and obtained that license, will the buyer have enough money to pay for the remaining 51% interest? Sometimes the mechanism there is to do a closing where 49% of the purchase price is paid, and then the 51% of the purchase price is held in escrow for the second closing and then released to the seller at that time. The other consideration, though, is if we're doing a build out for the buyer who's ultimately going to own 100% of the entity, the buyer should be entering into the lease agreements and contracts and paying for all of the build out costs and investments So as the seller, you're not only considering whether the buyer can pay for 49% or 100% of the entity when you're looking at the LOI and negotiating the terms. You want to know whether the buyer has the financial wherewithal to afford all of the build out costs.
That's a really great question because if we're not putting the other 30,000, let's say, in escrow for part of this secondary benchmark or close date, and
Mhm.
I'm, as an investor, offering a seller's note where I'm going to give maybe a lump sum payment every month or every 6 months or on the anniversary of the first close or some such timeline, I think there could be a little bit of risk there from the seller. If that buyer comes in and misses a significant payment, what does that
Yeah.
look like? How have we sort of seen that go down?
Wait, so I just structured a sale of a micro, so much, only in the 5-figure range. And we represented the seller. And because it was such a low amount, we required that what Ilana just mentioned, the second payment be held in escrow. So we're not chasing the buyer around trying to get that second payment. And we're also structuring it so that payment comes either when the 51% is transferred so that the buyer has 100% of the entity,
Mhm.
or at the expiration of 18 months, whatever happens first. So if that money is in the escrow and that buyer doesn't follow through and doesn't do the build out and never gets the license, you, the seller, are still able to get that sale price that's being held in escrow. And I love keeping money in escrow. I think that's the best way for anybody to structure it because, my background before cannabis is litigation. I litigate so much, and you're chasing people and you're spending money chasing people. And if somebody owes you $25,000, it could cost you $25,000 to chase them. So you don't want to do that. You just want that money to be in escrow so that you could grab it. So yeah, Ilana and I, we've talked about it. Like, talk about using escrows in your LOI.
Now, that might not work in all situations, but in micros, if the deal value is, let's say, more affordable,
Right.
I could see that working really well. But if we're looking at, 6 figures, 7 figures, where maybe the buyer wouldn't have all the cash up front,
Yeah.
are folks looking at implementing some kind of clawback if a missed payment happens, where the seller would just get everything back and inherit everything, if a missed payment occurs?
Yeah. I mean, those are all provisions that we try to put in there, or at least we talk to our client if they're the buyer, because again, those are risk mitigation steps that you take, right? You always try to protect yourself in case shit hits the fan. But one of the things, kind of just like going back, when Ilana was talking about the due diligence, I've had people, uh, I've had clients who were buyers have the misunderstanding or wrong understanding that just because these entities that they're buying from are brand new, that they couldn't possibly have any debts that they would be getting when they purchase the LLC. And that's not true. That entity could owe a law firm quite a bit of money. That entity could owe a consultant that they had hired to write the application. So that entity could have taken out a credit card and, and just lived high on the hog. So don't assume that LLC or that entity doesn't have any liabilities just because it's new, just because it's a newly formed company. And then also, what you're saying about not being able to hold all of the funds in escrow for the larger transactions. One thing Ilana and I, strategize on is holding back some of that money in an escrow, maybe 6 months post sale, post the final sale transfer, just to ensure that there isn't any kind of liability that they didn't know about that comes through the door. They don't, just in case they get a call from a law firm and you owe saying that they owe you $20,000 because that's what the previous owner did. If you keep some money in escrow to cover those, you are in a better position. And then after 6 months, if no liability show up, then they get released to that those funds get released to the seller. So there's all these like strategies and these little ways that we try to mitigate the risk for our client.
So these little emergency contingency funds can really help to control, in some regards, some of these little surprises that might present themselves once you're picking up the keys to your
Yeah,
new
yeah,
your new vehicle. Okay,
yeah.
interesting. So going back to the beginning, I guess, of the process and how these things get started. So that I think is like a big question that people are very curious about. Let's say Lucas's laundromat, they want a license. You know, we're all very, very excited here to look at maybe what it could be like to sell some of the equity or all the equity and completely divest in this business over some kind of period of time. You know, I contact the consultant or the law firm that worked with me. They put me in contact with maybe prospective sellers to get into a transaction. From what I understand, is that the terms sort of have to be somewhat close, you know, at the starting point, not necessarily the job to of the broker or the consultant to do a lot of the nitty gritty in terms of arguing about who gets what and when and all the finer points, but largely I guess you should probably have an understanding of like what's being sold, what is the approximate price, and what are sort of the first couple of terms that we're looking at in terms of like payments, right? So what is it? How much is it? When is it got to be paid? You know, once we sort of have found these folks, okay, buyer, seller, general terms, you know, we chaperone them to their respective counsel side. What are the steps that have to sort of take place from that point to, let's say, the buyer inheriting 100% of the equity? You know, what does that process look like to put together a deal?
So are you saying this is before or after a letter of intent is signed?
Even
Maybe
before?
starting at the letter of
Okay.
intent.
Yeah,
Oh,
so the letter of intent
just
would
terms.
probably be
Yeah.
the best first step. It's sitting down with the parties and discussing the who, what, where, when, how, and why.
Got it.
And some people like to insert some extra protections in there, like exclusivity clauses, that would give, you know, one or both of the parties the right to, the assurance that the other party is not speaking to other parties trying to get a better deal.
They're not
Um,
shopping it around.
Yep, uh-huh. And that and confidentiality clauses. So a confidentiality clause ensures that, you know, we're not talking to third parties yet about the fact that this deal is about to take place. We don't want them to disclose how much they're selling the license to me for. I don't want them to disclose the fact that I am planning to open a retail store in the city of St. Paul, you know, for instance. And those two clauses would be the only carve outs of the non-binding component of the letter of intent. Everything else is intended to be non-binding. So people always say, you know, why would I sign a letter of intent? What's the point if it's non-binding? Well, there are some things that we can say are exceptions to the non-binding component of the letter of intent, but also it just makes sure that everybody's on the same page. It's surprising how often I've seen deals fall apart just at the letter of intent stage because the parties didn't realize they were talking about two different things. One was trying to buy an apple, and the other one was trying to sell them an orange. And so, you know, that actually saves you a lot of time, energy, and effort on the front end if you can make that determination right away that you weren't talking about the same type of deal structure, or, you know, transaction in a global sense. Because actually purchase agreements are very expensive and more complex to put together than a letter of intent. So you don't want to have your lawyer work on a purchase agreement when in fact, you know, it was never going to, it was going to fall apart in the no matter what, because the parties weren't having the same conversation. Also, you know, a letter of intent helps your attorney to draft the purchase agreement in a more cost efficient and precise way. Um, if I don't get material terms or a letter of intent from my client, then I, end up having to have a lengthy call with them about all of the intended um, provisions, and oftentimes we're having to guess, did the parties desire to have an escrow built into the purchase agreement? Because that could be half a page of provisions right there on how an escrow is released and what other contingencies are there that could change the party's ability to consummate this transaction, for instance. One of the contingencies that should be in a purchase agreement in the state of Minnesota with respect to the license transfer is the ability to obtain OCM approval. So I might have mentioned earlier that once a seller party receives the license approval, in and they transfer the license to a buyer, the buyer also has to go through a vetting process with the Office of Cannabis Management. And if the buyer, for instance, has a crime on their criminal history, such as fraud, that might prevent the buyer from receiving that license transfer. And so that's another piece of due diligence that a seller could do, even at a LOI stage, is to investigate the criminal background history of their buyer to ensure that that transfer can be effectuated.
The other thing that um, I instruct clients to do that a lot of them don't is to ask if the selling entity has a operating agreement or bylaws or shareholder agreement in place. Because if they do, you want to take a very close look at the voting rights and how they are structured in those corporate documents, because as a 49% owner, um, you could potentially not have any say in the entity's main votes. Um, and
It's a
so,
really good point, Carol.
yeah, so I just did a LOI where it's a balancing act, right? Because you can have it where you can say, well, every vote requires 100%, but OCM is going to look at that, and that's an issue of control. They could say, no, that was inappropriate. So we try to make some carve outs where if it's a decision that will cost more than $5,000, then you need supermajority. If it's a decision on a contract that is longer than 6 months, then you need a supermajority. So you have those voting rights be a little bit more articulated so that if OCM comes up and starts, poking holes or making points on it, you can say, we didn't take over control. We were very surgical in how we did that. So always look at the corporate documents for the entity as part of the due diligence.
Well, and if I'm a buyer and I'm buying an entity that's, let's say, member managed, it's an member managed LLC, but I'm only going to own 49% of the entity during the build out process. And I know that this build out is going to be a very custom build out for me and my operations. I'm going to want to figure out how to still be able to carry the votes and the decision making with respect to all of those build out decisions. So perhaps there's a, requirement at the first closing where I'm receiving 49% of the ownership interest, but I am a manager that gets to make all of the decisions relating to the build out, because at the end of the day, I'm going to end up paying for all of it as the buyer. So, those are things that a buyer can do to ensure that they're getting precisely what they need, even though they're a minority owner of the entity, because they're the ones that are going to have to live with it after closing. They're the ones that are going to own 100% of the business and operate it.
Carol and Ilana, I really appreciate your take here. And from what I understand, it sounds like Vermouth and Johnson can support clients throughout this process. If folks are thinking about selling their license, they've been approached by a prospective seller, how can they get in contact with you?
Yeah, so you can find Ilana and I on our Helmuth and Johnson website. There was our contact information on the beginning. Ilana and I are both very active on LinkedIn also. So you can reach out to either of us, whether you're the buyer or the seller. We can work with you to protect your interests as you go through this risky process.
I appreciate that. Wanted to mention that for those looking to get some additional help, we have some amazing resources on our website. We have our ebook online, as well as several YouTube videos and many webinars pointed to what to do for post-licensing, license application process, cost of build-outs, all of that. Folks, we're going to go to our live Q&A, so please stick around. You'll be able to have the opportunity to speak with Ilana and Carol directly and ask them your burning questions about what it would look like to either buy or potentially sell the equity that holds your cannabis license in the state of Minnesota. Stay tuned.